Thursday, June 12th. Federal judge forces Secret Service to release classified internal evidence for Trump's immediate arrest. Case number 2, 6CR4891, filed 7:23 a.m. Eastern by U.S. District Judge Elena Vasquez. Emergency disclosure order, 38 pages. Page 6, paragraph 12 states, no agency tasked with executive protection shall withhold, suppress, or delay production of evidence material to active criminal proceedings against any individual, regardless of office held. Translation: Secret Service cannot hide evidence to protect the president from prosecution. Order enforceable immediately. No stay granted. Compliance deadline set for 48 hours. This has never happened. No federal court in American history has compelled the Presidential Protective Detail to surrender internal operational evidence for use in criminal proceedings against the sitting president they are actively protecting. Here's what matters. This isn't about one document. This isn't about one subpoena. This is about whether the agency sworn to protect the president can also function as a shield against criminal accountability. Two roles in direct conflict: protect the person, obey the court. As of 7:23 this morning, a federal judge said, you don't get to do both. Everyone's reacting to the headline. Nobody's explaining how we got here. How did a federal judge obtain the legal authority to override Secret Service operational protocols? How did prosecutors build the case that forced this order? I went through the filings, the sealed motions, the constitutional framework documents, patterns clear when you work backwards. Let me show you. So what evidence are we actually talking about? According to prosecution filings from May 29th, Secret Service has been holding 4 categories of material. Internal communications between protective detail leadership and White House counsel. Surveillance and access logs from Mar-a-Lago covering 11 specific dates between January and April 2026. Visitor records that prosecutors allege contradict official White House statements about who was present during key meetings. And protective detail shift reports showing unscheduled security adjustments on dates directly relevant to the criminal charges. Why did Secret Service have this? Standard operational protocol. They log everything. Every entry, every exit, every shift change, every communication regarding presidential security. That's their job. Why did they refuse to release it? Presidential security privilege. Secret Service counsel argued on May 14th that disclosing operational evidence would compromise protective methodologies and endanger the president's physical safety. Executive privilege claim filed the same day by White House counsel backed that position. Prosecutors issued subpoena April 22nd. Compliance deadline May 8th. Secret Service missed it. Prosecutors filed motion to compel May 12th. Secret Service responded May 14th with privilege assertion. Judge Vasquez held sealed hearing May 30th. Ruled June 12th. This wasn't sudden. Prosecutors spent 7 weeks building the legal framework to force this exact outcome. Every privilege argument Secret Service raised was already countered in prior sealed motions. By the way, Amazon is currently giving away $750 gift cards to eligible residents. Links in the description if you want to check that out. Now, here's where things get interesting. How does a federal judge override Secret Service? That's the question nobody's answering. Here's the legal mechanism. Start with the Constitution. Article 3 gives federal courts authority over all cases arising under federal law. No carve-out for protective agencies. No exception for presidential security details. Prosecutors knew this. Their May 12th motion to compel, page 9, paragraph 4, laid it out explicitly. They cited United States v. Nixon 1974. Supreme Court ruled unanimously that executive privilege does not override judicial need for evidence in criminal proceedings. Nixon had to hand over the tapes. President didn't want to. Court said doesn't matter. Then they cited Clinton versus Jones 1997. Supreme Court ruled sitting presidents are not immune from civil judicial process. Extended that reasoning to criminal evidence production in their May 22nd supplemental brief, pages 14 through 18. Then they connected it to Judge Morales's immunity rulings from June. If a sitting president can be arrested under the constitutional framework established 3 days ago, then the agency protecting that president cannot claim broader immunity than the president himself holds. That's the argument. Page 23 of the June 12th order, Judge Vasquez cited it directly. But here's what prosecutors really exploited. Secret Service has a dual identity problem. They're a protective agency under the Department of Homeland Security. They're also a federal law enforcement body. Law enforcement agencies are subject to judicial process. They comply with subpoenas. They produce evidence when courts order it. Every day, in every federal courthouse in America, prosecutors argued Secret Service cannot selectively invoke protective status to avoid law enforcement obligations when both roles apply simultaneously. Motion filed May 22nd, footnote 31, page 27. Judge agreed. That dual role became the legal vulnerability that made this order possible. Now the sealed hearing. The 30th of May, 2026. Judge Vasquez's chambers. 9 attorneys present. 4 from the prosecution. 3 representing Secret Service. 2 from White House counsel's office. Session lasted 2 hours and 14 minutes. Partial transcript unsealed June 11th as part of the disclosure orders supporting documents. Here's what it shows. Prosecution opened with an evidence preservation argument. Lead prosecutor stated Secret Service had already failed to produce materials by the May 8th deadline, and that continued delay created risk of evidence alteration or destruction. Cited 3 specific instances where internal communications referenced in earlier filings had been reclassified after the subpoena was issued. Secret Service counsel pushed back hard, argued disclosure of protective detail operations would create immediate security vulnerabilities, said releasing surveillance logs would expose methodologies that foreign intelligence services could exploit, called the subpoena a fundamental threat to presidential protection. Then Judge Vasquez started asking questions. And this is where the transcript gets interesting. She asked Secret Service counsel directly, "Can you explain why documents referenced in your own April 28th filing as routine operational records were reclassified as presidential security material on May 9th, one day after the compliance deadline?" No clear answer in the transcript, she followed up. The court has reviewed every reclassification order submitted since the subpoena was issued. The timing pattern is not consistent with standard security protocols. She'd already done the work. She'd already reviewed every document. By the time Secret Service counsel finished arguing, Judge Vasquez had identified the inconsistencies, mapped the reclassification timeline, and built her constitutional reasoning. This ruling wasn't reactive. She walked into that hearing with her decision already framed. Secret Service issued a formal statement at 9:41 a.m., 2 hours and 18 minutes after Judge Vasquez's order dropped. 3 paragraphs, carefully worded. Said the agency remains committed to fulfilling all lawful obligations while maintaining the highest standards of presidential protection. Read that again. They didn't say they'd comply. They didn't say they'd defy. They said lawful obligations. That's lawyer language. That's buying time. But the filings tell a different story. Internal communications obtained through the prosecution's May 29th evidentiary submission show senior leadership has been divided on this for weeks. Email chain dated May 16th between the deputy director and chief counsel. Subject line, subpoena compliance framework. Deputy director wrote, "We cannot be in the position of defying a federal court order. That is not who we are." Chief counsel responded same day. Compliance without White House authorization exposes the agency to executive branch retaliation. We need cover from above before we produce anything. That's the impossible position. They answer to the president operationally. He's their protectee. Their mission is his safety. But they answer to the court legally. Judge Vasquez set the compliance deadline at 48 hours from the order. Friday, June 14th, 7:23 a.m. Penalties for non-compliance. Agency-wide contempt finding, daily fines of $50,000, and personal contempt citations for the director and chief counsel individually. Enforcement mechanism. Judge Vasquez designated the FBI, not federal marshals, as the enforcement authority. That's significant. FBI operates under DOJ, not DHS. Different chain of command than Secret Service. Career agents inside the agency are watching this. People who spent decades protecting presidents, who swore an oath to the Constitution, now caught between 2 lawful authorities giving contradictory instructions. Protect the president, obey the court. As of right now, they can't do both. White House response came fast, suspiciously fast. First emergency motion filed at 8:14 a.m., 51 minutes after the order, 29 pages. You don't draft 29 pages in 51 minutes. They had this ready. They knew it was coming. White House counsel filed 3 separate motions before noon. First motion, emergency stay request arguing. Judge Vasquez's order violates separation of powers by compelling an executive agency to act against the president's direct security interests. Second motion, executive privilege assertion claiming all Secret Service operational material is inherently classified under Presidential Security Directive 12, signed by Trump in February 2026. Third motion, motion to recuse Judge Vasquez, arguing her prior rulings demonstrate prejudgment against the executive branch. Walk through what they're actually arguing. The separation of powers claim says courts cannot direct executive branch agencies on how to handle presidential security matters. That's the same structural argument the White House used against Judge Morales' arrest order in the earlier immunity fight. Prosecutors anticipated it. Their May 22nd sealed filing, pages 31 through 36, pre-rebutted this exact argument. The executive privilege assertion cites Presidential Security Directive 12. But prosecution's June 1st supplemental brief flagged that directive was signed 3 weeks after the subpoena was issued. Judge Vasquez noted that timing in her order, page 29, the recusal motion argues bias. Standard play, delay tactic. Every constitutional argument the White House raised had already been countered in sealed filings weeks before the order dropped. Prosecutors weren't reacting to the White House. The White House was reacting to prosecutors, and they were already behind. So what's actually in these documents? Based on prosecution filings and the partially unsealed transcript from the May 30th hearing, here's what legal analysts believe Secret Service is holding. First category, internal communications between protective detail leadership and White House counsel dated between January 14th and the 22nd of March 2026. Prosecution's May 29th brief alleges these communications contradict official White House timelines on at least 4 key dates relevant to the criminal charges. Specifically, the White House stated publicly that no meetings occurred at Mar-a-Lago on February 9th. Prosecution claims Secret Service visitor logs show 7 individuals entered the residence that evening between 8:15 and 11:40 p.m. 3 of those individuals are reportedly named in the indictment as co-conspirators. Second category, surveillance and access logs. Prosecution alleges these logs show entry and exit patterns on 11 specific dates that don't match official White House accounts of presidential activity. The May 29th filing, page 17, references material discrepancies between publicly stated presidential schedules and contemporaneous Secret Service operational records. Third category, protective detail shift reports. This one's significant. Prosecution claims unscheduled security adjustments were made on dates directly tied to the alleged criminal conduct. Specifically, standard protective protocols were modified on 3 occasions without documented justification. Normal procedure requires written authorization for any deviation. Prosecution alleges no authorization exists for these changes. Why does this matter for the arrest case? Prosecution's theory, laid out across 94 pages of filings, is that these records establish the president was present for events he denied attending, met with individuals he denied meeting, and directed security changes to conceal both. If that evidence says what prosecutors claim it says, it fills the evidentiary gaps defense attorneys have been exploiting since the indictment. That's why prosecution took the unprecedented step. They believe Secret Service is sitting on the evidence that completes the case. Allegedly. Documents are documents. You decide what they mean. What do experts say? Former Solicitor General, 28 years of constitutional litigation experience. Judge Vasquez's order is legally sound. The precedent from Nixon forward is clear. Executive agencies cannot withhold evidence of criminal conduct behind security classifications. The dual role argument prosecution used regarding Secret Service is novel but well constructed. Translation, the legal framework holds. Constitutional law professor at Georgetown, specialist in separation of powers. Different take. The order is legally defensible but institutionally dangerous. Once you establish that courts can compel protective agencies to surrender operational material, you create a mechanism that future prosecutors could abuse. The precedent extends beyond this case. Key distinction there. She's not saying the order is wrong. She's saying the door it opens is wider than people realize. Former Secret Service director served under 2 administrations. This fundamentally changes the relationship between protective details and the individuals they protect. Agents operate on trust. If protectees believe their security team's records can be subpoenaed in criminal cases, it changes what gets documented. That has long-term security implications nobody's discussing. That's a practical concern, not a legal one, but it matters. Former White House counsel who served 3 presidents pushes back harder. Executive privilege exists for a reason. Presidential security material is classified for a reason. This judge effectively ruled that criminal prosecution overrides presidential safety. That's a value judgment, not a constitutional principle. Consensus among legal experts: the order is likely legally valid. The constitutional questions are real, but secondary to the criminal evidence question. The long-term precedent concerns are legitimate from both sides, where they agree this has never been tested before, where they disagree whether it should have been. Here's what's coming. Compliance deadline. Friday, June 14th, 7:23 a.m. Eastern. That's 48 hours from the order. Secret Service must produce all 4 categories of evidence or face agency-wide contempt, $50,000 daily fines, and personal citations against the director and chief counsel. White House emergency stay request currently pending before the D.C. Circuit Court of Appeals. Hearing scheduled Friday, June 13th, 4 p.m., 1 day before the compliance deadline. That timing matters. If the appeals court grants a stay Friday afternoon, the compliance deadline is paused. If they deny it, Secret Service has less than 16 hours to produce everything. Congressional response. House Oversight Committee announced emergency hearing Monday, June 16th. 9 a.m. Senate Judiciary Committee scheduled classified briefing Tuesday, June 17th. 3 tracks all moving simultaneously. Track 1, Secret Service complies. Evidence enters the criminal case. Prosecution files supplemental charges within days based on new material. Defense strategy collapses because the evidentiary gaps are filled. Arrest proceedings accelerate. Track 2. Secret Service defies. Judge Vasquez activates FBI enforcement authority. Contempt findings issued against agency leadership individually. Constitutional standoff between DHS and the judiciary with FBI caught in the middle. This is the scenario nobody wants because it forces federal agencies to choose sides. Track 3. Appeals court intervenes. Stay granted pending full constitutional review. Evidence production paused for weeks or months. Prosecution timeline stalls. Defense claims vindication. Case enters prolonged appellate litigation that could reach the Supreme Court. How they connect? Track 1 ends the evidence fight and accelerates the arrest case. Track 2 escalates into interagency constitutional crisis. Track 3 delays everything but preserves the legal question for higher courts. Friday's appeals hearing determines which track we're on. Watch that ruling. Everything follows from it. Here's what this comes down to. If Judge Vasquez's order stands, the precedent is permanent. Presidential protective agencies can be compelled to release evidence in criminal cases against the president they protect. That changes the calculation for every future president, every future investigation, every future Secret Service detail that logs a visitor, records a communication, or documents a schedule change. Before this week, that material was functionally untouchable. After this week, it's subpoenable. If you believe in presidential accountability, this precedent means the people closest to the president can't become a firewall against criminal investigation. The evidence follows the law, not the office. If you believe in executive security, this precedent means protective operations are now permanently exposed to judicial process. Every record created to keep the president safe can be turned into evidence against them. No neutral ground here. Both concerns are legitimate. Both will be litigated for years. What's undeniable, the relationship between presidential protection and criminal accountability just changed permanently, regardless of what happens on appeal. Now look, whether this precedent holds or gets overturned, one thing is obvious. The systems that are supposed to hold power accountable are being stress tested in real time. Most people are watching this unfold feeling like none of it is in their control. And honestly, most of it isn't. But there are things you can actually take advantage of right now while everyone else is just watching. Amazon is currently giving away $750 gift cards to eligible residents in the US, UK, Canada, and Australia. Real opportunity, takes about 30 seconds to enter. Click the link on my channel page to get started. If you're watching on a bigger screen, a QR code is about to appear right now. Open your phone camera, point it at the square on screen, tap the link that pops up. That's it. If you're watching on your phone, even easier. Tap my channel profile picture to go to the channel page. You'll see the link right there. A screenshot's about to appear on screen showing you exactly where to find it. This is one of those things that takes almost no effort and could actually pay off. Don't sleep on it.